All right, so good afternoon, everyone, and welcome to the Navigating Entrepreneurship webinar series hosted by Syracuse University's Daniello Institute for Veterans and Military Families. This free monthly event highlights SBA's Community Navigator Pilot Program, or CNPP, and the programs and resources entrepreneurs need to recover, grow, or start a business. If there's a topic you'd like to learn more about in the future training sessions, please reach out to me via email at ajlalond@syr.edu, and I'll put that in the chat box. As a reminder, this webinar will be recorded. By continuing to be in the meeting, you are consenting to be recorded. And we encourage you to use the meeting chat box to ask questions and engage with other participants during the discussion portion of the webinar. So today you'll be hearing from Allison Wyman, a military spouse and experienced caregiving attorney who has practiced in estate planning, health insurance, elder law, and estate administration. She will be sharing information about what business owners should know about having an estate plan for their business and what to consider to protect your family and business, as well as some example estate plans for small business owners. Please note that the information shared during this webinar is for informational and educational purposes only. This means that you will not be entering a formal attorney-client relationship with Allison, and she cannot give webinar participants legal advice. If you do have any additional follow-up questions for Allison following the webinar, please email me or Allison, and I'd be happy to connect you. And I will now turn it over to Allison to kick off the webinar.
Thank you so much, Amanda. Hi, everyone. My name is Allison, and thank you so much for being here. I am a family caregiving attorney with my own law office, the law office of Allison K. Wyman, and today we're going to talk about two of my very favorite topics, the topic of entrepreneurship and the topic of protecting your family, and you protect your family in life and in death through estate planning. So just as a disclaimer, which I know Amanda stated, this information is just for educational purposes. It doesn't constitute legal advice, but one of the really neat things it seems comes from this program is there are available office hours. So like Amanda said, please reach out to her or reach out to me directly, and I'm happy to set you up with an office hour and we can talk about some of the questions you have and see if there are some solutions out there for how to move forward in your business and in your estate planning. All right, here are the goals of the presentation. Today, after this hour, I hope that you leave feeling confidence regarding general estate planning principles. What are they? What do they do? And why are they important? And then common estate planning issues that are faced by business owners, as well as some potential solutions. Okay, estate planning is an act of love for the people you love. I say this all the time, and here's what I mean. By you being here today, taking time out of your very busy day to learn a little bit about estate planning, you are showing up actively for the family members in your life and for the people that you love. And the message that you're sending and the steps that you're taking are saying, I want to be here for you and protect you in every way I can, even when I'm no longer alive. So when somebody dies, what happens is the family grieves and they think things can't get worse. And as an estate planning attorney and a family caregiving attorney, what's really terrible is because of some estate planning practice or something that hasn't been done that could have easily been fixed in the person's life, things actually do get worse for the family. But by you being here today and learning the foundational knowledge that we're going to go over together, you're moving one step in the right direction to making sure that doesn't happen for your family. The second note is the note about the entrepreneur mindset. So if you're here, you're most likely an entrepreneur. And so you might be thinking, oh my goodness, Allison, I give everything I can to my family and to my other obligations. And with everything that's left in me, what I'm doing right now is just trying to get this dream, this idea off the ground. I am just trying to get it to fly. So why are you bringing me down by talking about my death? If you're feeling that way, I totally understand. Don't feel bad. And I promise that this presentation actually isn't going to bring you down because as entrepreneurs, one of the things that we have learned is that we can't take meaningful and uncomfortable and the right steps or the forward steps that are necessary unless we know where we are. And so that's what this presentation does. Is this presentation is going to provide what the default statutes are in New York State for certain types of estate planning and business. So we're not necessarily going to dive into the nitty-gritty worst case scenarios. We're just going to talk about right now as an entrepreneur and a family member with people you love and you care for and you want to protect. If nothing happens, what does that mean? Where are you on the map? So what I'm actually hoping is that this presentation will be empowering in two ways. One, you will have the basic knowledge and hopefully framework for understanding estate planning and understanding the entrepreneur mindset around estate planning so that you, if you have any lingering questions or fears, will at least have enough knowledge now to know, oh, here's something that I need to look into, or here's the next question that I need to ask. Two, I hope that you take away from one of the things I hope you take away from this is that coming up with your estate plan and coming up with how your business joins your estate plan is not something that you have to do alone or should do alone. You really should do this in consultation with someone like an attorney who can provide not only professional experience and level-headed knowledge, but also provide an overview and a framework of what you need to consider without necessarily the emotion that may come up in today's presentation. So I really, really hope that this presentation actually becomes a reassuring element of your entrepreneurship journey because you know now a little bit more about estate planning, and you also know you're not alone and you shouldn't go it alone when it comes to making your plan. All right, here is a basic estate planning review for all of you people who are visual learners. So in the pink, you have the different estate planning components that are active and something that occur and have real life when someone is alive. So your healthcare proxy, your trust, your living will, your power of attorney, and we're going to go over what these are in a second. All of these elements are things that apply to a person during their lifetime. Now, the items in yellow, the will, a testamentary trust, and a designation of standby guardian, those are elements of an estate plan which pop up and become relevant once somebody passes. So that's a really important distinction because when you create an estate plan, of course, you create it all at the same time, but it's really important to know that there are elements that work during your life and elements that work during your death. I like to think of all of these elements as your all-star team. So here is your team, these are your players, but they have different roles and they have different timelines. Most importantly, I just want to point out here the power of attorney. Again, we're going to talk about this during the presentation, but I want to point out here that the power of attorney is in pink, which means the power of attorney only applies when you are alive. So I wanted to include for those that really like to have all of the statutory language. I wanted to include longer definitions here, but a will is just a written instrument that's formally executed following state laws, which basically, upon a person's death, helps dispose of that person's property. And then a trust, which we're not going to get into trust too much today, but just in case it's something either that already is a part of your estate plan or something that you've wondered about, a trust is just a legal vehicle which allows for this relationship where somebody holds title to property for the benefit of somebody else. And so in New York, trusts can be testamentary trusts. And remember that testamentary trust was in yellow. So that's a trust that pops up once somebody dies and becomes effective. Or it can be a lifetime trust known as a revocable trust. Lifetime trust can also be irrevocable trusts, but we're not gonna talk about those today. Lastly, a trustee is someone who administers the trust based upon the trust agreement. All right, so here are the items that were found in pink. You have your healthcare proxy, your living will, and your power of attorney. Your healthcare proxy is a document where an individual made by the principal delegates to an agent, another person, the authority to make healthcare decisions for and about the principal. So a healthcare proxy is where you say, I'm going to trust someone else to make my healthcare decisions for me when I'm no longer able to make them. A living will is an advanced healthcare directive detailing certain medical measures a person wants and doesn't want, and often goes hand in hand with a healthcare proxy. And then a power of attorney is a legal instrument where the principal authorizes another person, an agent, to make financial, business, and some personal decisions for the principal. So we think about a healthcare proxy and a power of attorney as making decisions for the principal while they're still alive, but unable to make decisions for themselves. And the healthcare proxy is making decisions about health care for that individual. And the power of attorney is really making almost all other decisions for that individual. And then the designation of standby guardian. If you haven't heard of a designation of standby guardian, this is a form that essentially allows parents of minor children to name the standby guardian or the person that they would want to care for their minor child if a single parent or if you have two parents, both parents die. So a designation of standby guardian provides a lot of comfort to parents because it allows them to affirmatively do something other than name a guardian in their will, which they also should do. It allows them to affirmatively do something to put out in a official legal document who it is they want to care for their children if they're no longer able to do so. So we talked at the beginning how this presentation is going to look at what the default is. The default if you do nothing. So what happens if I die without a will? A validly executed will allows you to name the person in charge of distributing your estate, which is your executor, and dictates how that estate should be distributed. When someone dies without a valid will, that person dies what's called intestate. That means who distributes the will, known as the administrator, and how the estate is distributed is governed by New York laws. And this outcome is oftentimes not desirable, which is why everyone should have a will. Now, here is the statutory language for the distribution of estate if someone dies intestate or dies without a will. But we're going to go into an example to give it even more life. So, in this example, husband Henry dies without a valid will, leaving wife Wanda and minor children Charlie and Charlotte and a $50,000 estate. I'm sorry, Amanda. I'm not sure. Are you hearing that? Okay, I just wanted to make sure. Okay. So husband Henry dies without a valid will, and he leaves his wife Wanda and his minor children, Charlie and Charlotte, with a $500,000 estate. Henry wants the entire estate to go to Wanda to support her so that she can raise the children. However, under New York laws, if Henry doesn't have a will, here's what would happen. Wanda, his wife, would receive the first $50,000. So that leaves an estate of $450,000. Then that remaining estate of $450,000 is divided, and Wanda takes half, and the children take half to split. So this leaves Wanda with $275,000 and the children with a total of $225,000. But because the children are minors, they can't legally accept this money. So what that means is the money is going to be held in some type of account or trust until the children turn of age, and it's likely the court will be involved to some degree to oversee this money. So here, Henry wants all of his money to go to his wife so his wife can provide for their children. And what we see is without a will, what actually ends up happening is $225,000 go to his children, but it's not accessible to them because they're minors until they become of age. All right. So now let's turn to the common estate planning concerns for business owners. And here are the three that we're going to cover. One, do you want your business to continue after your death? Two, what are additional estate planning considerations as my company grows? And then three, what if I become incapacitated and I can't run my business? Question one, do you want your business to continue after your death? I would say that when it comes to estate planning, this is probably the number one question that you should ask yourself. And under New York law, depending upon the type of legal entity that your business is, that question is answered for you. So we're going to go dive into each one of these, but first, sole proprietors, the business really doesn't continue after the owner's death. For general partners, I wrote no and yes, which we'll get into. And then for limited liability companies, yes, it is possible legally for the business to continue after the owner's death. Now we're going to talk about sole proprietorship. So in a sole proprietorship, the sole proprietor is personally responsible for all the debts of the business, and the sole proprietorship is not treated as a separate taxable entity, which means business income is reported and taxed through the sole proprietor's personal tax return. Now, one thing about being a sole proprietor, I think sometimes in the entrepreneurship world, there's this tug of like, oh, well, it's pretty easy to become a sole proprietor in New York and to start doing business. And I really just want to hit the ground running, but I have in my head that this is going to be a huge business. And so it's actually not okay for me to try to be a sole proprietor right now or to think about my business as a sole proprietorship because that will somehow have meant that I failed before I even started. But here's the thing. When it comes to estate planning for your business, the best thing that you can do for yourself and for your family and the people that you want to protect is to be honest. And so things change, which means your business entity can change, which means your estate plan can change. But right now, if you are the talent in your business, you are the reason that the business thrives, and without you, this business will not run, then being a sole proprietor may in fact be the right avenue for you to take. And what that might mean is right now, where your business is now, that upon your death, the business won't continue. It won't continue, right? Because you're the talent. So a sole proprietorship, because the owner, the sole proprietor is the talent, doesn't survive the death of the owner. And so what that means is that upon that owner's death, the business is wound up by the legal representative who's named in the will to handle the business. And then any remaining cash assets are included in the decedent's estate. So in this situation, say that you're a sole proprietor and in your business, aside from your actual cash and your actual expenses that you need to make, you have something valuable like a recipe. Now, that recipe, again, because the sole proprietorship isn't separate from the individual, that recipe is something that you can pass down through your will. So if you have a special recipe that you're using as part of your business, you can include that as something special that you are giving to somebody as a special provision of your will. Now, in general partnerships, a general partnership, just as a quick summary, is formed when two or more persons carry on a business for profit and where each partner shares pro rata in the profits, losses, and control of the partnership. A general partnership is not a separate taxable entity, which means that the business income is taxed through each general partner's personal tax returns. Each partner is in a general partnership, each partner is also jointly and severally liable for all the debts and obligations of a partnership, in addition to other partners' actions when they're acting relating to the partnership. So as a result, this isn't a business entity that owners often choose due to these liability issues. But with that said, we did want to provide some context about what default is when it comes to general partnership estate planning in the laws of New York. So under New York law, the death of a partner causes the dissolution of the general partnership. Now here, dissolution just means a change in the relationship between the partners. It doesn't mean the general partner has to terminate. In fact, upon the death of a partner, there are really two things that can happen. So if the general partnership is following these default New York laws and say there are two partners and one partner dies, there are really two major avenues that the partnership can take. One is that the partnership can essentially be terminated, which means that it'll be wound up and that all the liabilities will be paid for. And if there's any remaining cash on hand after that, that will be distributed pro rata to the partners. And then if one of the partners is deceased, it will go to that estate and it'll become part of that partner's estate for purposes of probate. The other avenue that can happen is that the partner dies, so one of the two partners die, and the second partner, the other partner decides they want to continue the business. And so maybe the second partner continues the business with the heir of the partner who died. So maybe the child of the partner who died becomes a partner in the partnership with the other original partner, and they form a new partnership and the business continues. So just because a partner dies, it doesn't necessarily mean that the business itself dies. But of course, there are going to be a lot of details that need to be figured out. And one of the things that will help figure out the details of what can happen and when it can happen is a partnership agreement. Now, a partnership agreement isn't legally required for general partnerships, but it's heavily suggested because what it does is it lays out the foundation for how the partnership is going to act and what the general partners how the general partners are going to interact with each other. Now, one of the great things about New York law is that there's a default, but then sometimes if you have something like a partnership agreement can override elements of the default law in New York. So like a will overrides the intestacy statutes, and the intestacy statutes, again, are what happens to your belongings if you don't have a will. Having a partnership agreement allows partners in a general partnership to override some of the default general partnership laws that exist. Now, if a partner applies to the court to dissolve a partnership because a partner has been declared incompetent or because a partner is incapable of performing his part of the partnership contract, the court may grant that. And I included this here because oftentimes when we think of estate planning, we think about, well, what happens if someone dies? And what I really want us to do is think about not only death, But also think about incapacity. What happens if I'm still alive, but I'm not able to contribute the way that I normally would? Now we're going to talk about limited liability companies. And here it's my understanding that there's probably more of you that have or are considering an LLC. So I thought we would dive a little bit deeper into the LLC laws and what that can look like for your business and for your estate plan. All right. So a limited liability company is just an unincorporated organization of one or more persons who have limited liability for the contractual obligations of the business. And so just like the general partnership had a partnership agreement, the limited liability company has something called an operating agreement. And an operating agreement is a written agreement of the members of the limited liability company concerning the business of the LLC, the conduct of its affairs, and the conduct of its affairs. So basically, your operating agreement for your LLC is where the members of the LLC decide how the LLC is going to run. Generally, members and managers of a limited liability company are not liable for the debts and obligations or liabilities of the limited liability company or each other. However, for LLCs with employees, the 10 members with the largest percentage ownership interest are jointly and severally liable for all debts, wages, and salaries due and owing to any of its laborers, servants, employees for services performed by them in New York for the LLC. This slide shows what the default is when it comes to voting rights and asset distribution if there isn't an operating agreement that says something different. So basically, profits and losses as well as distributions are allocated among the members in the manner provided by the operating agreement. But if there isn't an operating agreement or it's silent, distributions occur based upon the contributions of each member. Now, new members can also join an LLC. So a new member to an LLC can be admitted so long as they're in compliance with the operating agreement, or if the operating agreement doesn't provide upon the vote or written consent of a majority of its members. So a membership interest can also be assigned as provided by the operating agreement. And what assigned means is that the economic interest. So someone who's assigned an interest through the operating agreement is not entitled to engage in the management of the LLC, but is entitled to distributions and allocations and profits and losses that the assigner would be entitled to. So in an LLC, when a member dies, unless it's provided differently in the operating agreement or the articles of organization, the LLC still has perpetual existence. So what that means is that when a member of the LLC dies, unless it says something different in the operating agreement, the death of the member doesn't cause the LLC to be dissolved, or it doesn't cause the LLC's to have its affairs wound up. The LLC can continue for 180 days unless there is a vote by the majority of the LLC members, unless within that 180 days, there's a vote by a majority of the LLC members to dissolve the LLC. And anytime there are no members of an LLC, so this is if there's a single member LLC, unless otherwise provided in the operating agreement, the limited liability company is not dissolved and is not required to be wound up if within 180 days or period stated in the operating agreement after the death of the last remaining member, the legal representative of the member who died agrees in writing to continue the limited liability company and is admitted to the LLC as a member, and that admission is effective as of the date of death of the member who died. So if a member dies, so if an LLC member dies or is adjudged incompetent, so again, we're talking about death, but we're also talking about what happens if someone's alive but isn't able to carry on in the way that they normally would, the member's executor, administrator, guardian, conservator, or other legal representative can exercise all of the member's rights for the purpose of settling his or her estate or administering his or her property, including any power under the operating agreement of an assignee to become a member. And I just want to note, we're not going to cover them now, but there are other types of LLCs in New York. You have foreign limited liability companies, you have professional services limited liability companies, and you have foreign professional service limited liability companies. Okay, so here are our pathways examples for what can happen if a member of an LLC dies. So if the owner or the founder of an LLC dies, the LLC can close and it can be liquidated. Or the remaining LLC members can decide they want to buy the deceased member's interest. And so to buy that interest, there needs to be enough cash on hand to do so. And one way that some companies decide to go to ensure they have cash on hand is they'll have something called a buy-sell agreement, which basically says if one owner dies, if one member dies, somebody else or the remaining members are going to buy the interest, and then they'll purchase life insurance policies, which will provide them the cash to be able to do so. I should also mention that there are situations where, say, you have a two-member LLC, and when one member dies and then the other member wants to close it, the family of the member who died actually wants to keep it open. And so the family may actually be the one who decides that they want to come up with the cash to buy out the other member. Now, if the family wants to do that, and oftentimes that really is something that should be decided with an attorney and with in view of all of the other responsibilities and liabilities in mind, that family is going to have to come up with the cash. But we also want that family, if someone has died, we also want that family to be doing their own liquidity analysis to make sure that now, in light of this family member's death, they still have enough money to, one, live their everyday life, and two, wind up the estate of the person who died. Another avenue that can happen if an LLC member dies is that the legal representative, so say you have a single member LLC and that member dies, the legal representative, so say you've named somebody to be your legal representative to take care of your affairs on the business side. That legal representative can become a member of the LLC under law, which we just learned. And then in a fiduciary capacity, that legal representative can decide what to do. And then lastly, the operating agreement or another mechanism may allow somebody to actually become a member on behalf of the deceased member. So remember that when somebody dies, they still have, there still is that interest in the business, and that interest has a value. And so we've talked a lot about what happens if that interest or that value is given to somebody else, but that interest can also be assumed by somebody. One of the things I want to state here is if you're in a position where, say, you have a couple of children and you really think that one of your children would be a great fit for the role. So upon your death or when you step down, you want that child, if that child wants to fill the role, one thing you want to be thinking in your estate plan, as you're thinking through your business plan, is what that means for the overall distribution of your assets and what that means in terms of the other child, the one that won't be stepping into the business role, what it is that you will want them to receive in your estate plan. Okay, so the second concern is, what are additional estate planning considerations as my company grows? Now, here, what happens is people say, okay, well, I'll create an estate plan, but How do I know that I need to revise it? So, generally speaking, when you have an estate plan, um, because estate plan is meant really to protect a family and to protect a business, and families and business are living and they're growing and evolving. Your estate plan should live and grow too. But one sort of good way to think about whether or not you need to think about if your estate plan is something that needs to be revised is you can think, have there been any births? Have there been any deaths? Is there a divorce or is there a disease? So those are the four things that really should trigger an alarm of like, okay, I should at least review my estate plan to see if it needs to be revised. Now, in the business context, one of the biggest things you can do to continue to protect your family through the estate plan you have is to think about the valuation of your business. If your business continues to grow and grow and grow, which is so, so wonderful, you most likely are going to need a new um, estate plan that accounts for that. And so, one thing we've talked about, right, is personal liability as it relates to the legal entity that your business is. So, if you have a multi-million-dollar business, but you're still a sole proprietor, we know that as a sole proprietor, you are still 100% personally liable for that business. And so, that most likely won't make sense anymore. And so, that's one thing you can do as you think about your business overall, and you also think about protecting your family, is you can revisit what type of legal entity your business is and whether or not that needs to change. The other thing to consider if you have a business that grows and grows and grows is to think about the estate tax, if any, that might be due. Now, there is a federal estate tax of $12.92 million, but that may be reduced dramatically in 2026. And there is a New York estate tax of $6.58 million. To put this in context, we've talked a lot about what is included in the estate of somebody who dies. Now, there's something called the probate estate, which are uh, any property of the person who passed, of the deceased person, which is any property that has to go through the surrogate's court. That's considered the probate estate. There's something different, which is considered the taxable estate. And that's what the estate tax looks at. The taxable estate is actually bigger than your probate estate because your probate estate excludes certain things. For instance, any accounts that pass by beneficiary designation, that's not included in your probate estate because you don't need surrogate's court to help you dispense of those items. But anything that you own when you die is ultimately part of your taxable estate. And if your taxable estate is big enough, you will have to pay estate taxes. And your business value, the interest you have in your business, as we've talked about, has a financial value. And how you get there is based upon calculations given out by the IRS through certain regulations. But that value that you have in your business, should you own and be a part of your business when you die, that's going to be added on to all of your personal property, including things like a home. So, what we want to do is we want to look at how much, if I add everything up, do I have when it comes to my personal property, and how much is my business valued at? And you want to add those things together, and that becomes it's a messy calculation, but a quick calculation of your gross estate. And if your gross estate is larger than in New York, $6.58 million, or on the federal level, $12.92 million, you are going to owe estate taxes. And although we're not going to go into them today, that's where much more advanced types of trusts come in. And so if that becomes something that you have an issue with or that you're concerned about, definitely work with an estate attorney who will be able to guide you as to what could be the best vehicle for you and your family and your business. All right, the third concern, what if I become incapacitated and I can't run my business? So we've talked a lot about what happens if somebody dies. Now let's talk about what happens if somebody's still alive, but they're not able to function as the leader that they normally would be. So this is where the power of attorney comes into play. Remember that the power of attorney was in pink, which means that it is one of the players of your all-star team during the life of the owner. So a power of attorney is effective throughout the life of an individual, depending upon how it's drafted. So if, for instance, the owner goes through an illness and as a result isn't able to run their business, but doesn't necessarily want to give it up right now, there's a way where the person who is the agent under a power of attorney has the legal authority to assume responsibility for the business and essentially run it as if they were the original owner. This is also where succession planning comes into play. Now, when people talk about succession planning, they're often talking about how to make sure that your business continues on past your death. And of course, that makes sense, right? Like, how do you pass your business on to the next generation? Let's talk about that. I also think that succession planning should include how can I make sure that my people, my team, my clients are taken care of if I'm no longer able to do it, either permanently or temporarily? And so there are sort of the ways that I think about it. I think about two big umbrella terms, and yes, they do overlap, but the one umbrella term are your people, and then the other umbrella term is your money. So when it comes to people, this is when I think about your team, your employees. Are your teams prepared to succeed without you there? And in your absence, what gaps need to be filled? And can those gaps be filled by already existing team members, or does someone independently need to step in? Under the people tent, you also think about your clients. You think, if, for instance, tomorrow I was not able to come into work and that was going to be the status quo for an unknown period of time, would my clients be okay? Would somebody else be able to come in and make sure that their accounts are either closed up, or if there's an emergency or there's an issue that those issues would be able to be dealt with? So those are the kinds, when I think of succession planning under the people umbrella, I think of those questions and the systems that would need to be in place to answer those. The second umbrella is money, because, right, money is the lifeblood of a business. And so one of the things that I always think about are expenses, especially monthly expenses. So you would never want to be in a situation where you become incapacitated, you want to close down your business, or you think your business has closed down, but actually those monthly or quarterly or annual expenses, they continue to pile up. And so one of the questions you might want to ask yourself in this concept of succession planning and preparation is, what are my annual, monthly, and periodic expenses? What are the costs? Are they paid automatically? From what accounts? How are they pulled? What are the passwords and the usernames and the websites for how someone else could access those accounts? So it's really just creating a system for thinking through the expenses that your business would have that would allow someone else, someone like your power of attorney, to legally step in and to make sure that your business doesn't continue to incur unnecessary fees and unnecessary services if, for instance, you're incapacitated and you want to shut your business down. So that comes to the end of my presentation. And just as a recap, what we've talked about today is the concept that there are estate plans, and you have estate plans for individuals, and each individual develops their own estate plan to protect their family. But if that individual is part of a business, then that business and what happens to that business and the value of that business and where that value is going to go and how it's going to flow after someone passes also has to be a part of that estate plan. So there's the initial developing of the estate plan, and then there's the recognizing that, especially on the business side, if the business is growing and growing and growing, then that's great. And your estate plan is likely going to need to change to at least recognize the different valuation of this business and to account for that. And then lastly, when we think about estate planning, it's not just thinking about death, it's also thinking about incapacity. And there are systems in place that really aren't too terribly difficult to set up to make sure that if you become incapacitated, your a legal representative, say under a power of attorney, would be able to step in and either manage and do the business, support your teams and support your clients, or close down the business and be able to ensure that your business isn't incurring unnecessary costs. Thank you so much for your time and for your attention. I'm happy to take any questions, and I'll pass it back to you, Amanda. Thank you.
Thank you so much, Allison, for presenting for us. And I also want to thank our partners at the Military Spouse JD Network Foundation. And also thank you to all of our participants who joined us today. If anyone has any questions, we encourage you to put them in the chat. We'll wait around for a few minutes. And if not, you are all free to enjoy the rest of your afternoon. We really appreciate everyone joining us today. And thank you so much.
Hi, Mary. Is it okay, Amanda, if I jump in?
Of course.
Okay. Hi, Mary. Thank you so much for the question. If it's okay, Amanda, is it typically, do you just read the question out loud since it's gone to
Yeah,
everyone?
absolutely.
So do you want to read it out loud or should I? Okay.
Yeah, so Mary has asked, she said, wonderful presentation with critical information. And she's asked, how universal is all of this with other states versus New York State? Mary's in North Carolina and was going to start setting up an LLC soon.
That's a really great question, Mary, and thank you so much for asking. So the specific language that was included in the presentation today about LLCs, that's from New York law. And so basically, I'm a New York licensed attorney and I practice in New York. So what I am is I'm giving you New York law, and like we talked about defaults, what the New York default is and what the operating agreement is allowed to do to revise those defaults. With that said, the general idea about having an estate plan, having your business fit into that estate plan, and then if you have an LLC, if you're going to be a single member LLC, thinking about what happens when I die, and do I want my business to continue? And if so, how? Do I want somebody to run it? Those, like these general themes and framework, are universal and apply in any state. But once you've asked these universal questions and you've answered them for yourself, you will want to consult with an attorney from your state to make sure that you understand what the business laws allow and how you can work within those business laws to do what it is that you're trying to accomplish. You're welcome. Thank you, Mary. Are there any other questions? Well, I really would encourage, here is my email address. I really would encourage people, if they have questions, please reach out. I know that office hours are a part of this, so I'm happy to do a consult for free, of course. And I really just know that I want your business to succeed. I want your family to succeed. And as a military as a former, my husband and I are no longer active duty, but as a military family, and we were a military family for 10 years. Like, I so deeply love and respect what all of you are doing. And if there's any way that I can play a part in making your next chapter a success, I very, very much hope that you will call upon me. Thank you.
Thank you so much, Allison. We really appreciate you.
Well, thank you so much.
Have a great afternoon, everyone. Thank you so much for coming.
Bye.
Bye.